So we're going to follow up on Justice Busby's description of what has happened here in Texas. They saw a problem. They realized that at least part of the solution lay with rules that are promulgated by the court, and they meant to do something about it. So they asked the Access to Justice Commission to look into the potential solutions, and I'm joined today by two members of the commission who helped lead that effort. Michael Massengale is a former justice on the Court of Appeals for the First District of Texas in Houston, and since 2020, he's worked as an arbitrator and mediator at JAMS, the dispute resolution firm. And Kenan Wooten, to my immediate left, is a partner at Scott Douglas and McConaughey. She joined the firm in 2011 after working as the rules attorney for the Supreme Court of Texas, and also having worked at Baker Botts and as a law clerk to former Chief Justice Wallace Jefferson of the Supreme Court. So Kenan and Michael, let's jump right into it. Justice Busby sort of teed up how it is you came into being as the subcommittee's tasked with examining the existing court rules for opportunities to improve the services directly to low-income people. Michael, do you want to start off and talk about the committees that were set up and how you went about your work?
Sure. Well, thank you, Ron, and we want to thank the Legal Services Corporation for inviting us to speak this afternoon. We're certainly grateful to everybody in this room for all that you do to improve access to justice for those who need recourse in the courts but are unable to pay for lawyers under traditional service models. I think we're all aware of the justice gap, or as Justice Busby was referring to it, justice chasm, which I think is appropriate. Some of the statistics that we uncovered and we're using in our work for the last year, 90% of civil legal needs of low-income Texans are currently not being addressed by our system of legal aid and pro bono. We've got one legal aid lawyer for every 7,000 Texans who qualify. And so based on those shameful statistics, there really shouldn't be any genuine debate about the need to do something more than what we are already doing to address it. Fortunately, our state Supreme Court has been a true vanguard in this area. In 2015, our Supreme Court created a Justice Gap Commission, which issued a final report in 2016 with a series of recommendations to, among other things, increase data collection in this area, ensure adequate funding for self-help resources, and as became relevant to our work, to promote innovative technological solutions, including an examination of whether there are legal ethics rules that need to be revised to eliminate obstacles to innovation. So now, more recently, coming to the present, October 2022, the Supreme Court sent a letter to the Texas Access to Justice Commission requesting that we, and Ken and I are two of the commissioners, ask that the commission study existing rules and propose modifications in the two areas that were mentioned by Justice Busby, allowing qualified non-attorney paraprofessionals to provide limited legal services directly to low-income Texans, and also to allow non-attorneys to have economic interests in entities that provide legal services to low-income Texans while preserving professional independence. This is not a radical suggestion. As Justice Busby mentioned, other states are studying the same types of reforms, and some have implemented them. But the court's request to us was unique in some respects, particularly in that we were asked to really focus on applying these reforms specifically to aid low-income Texans. As chairs of the working group, we divided the study into three subcommittees, one focusing on the scope of practice of what these licensed paraprofessionals could do without the direct supervision of lawyers. Secondly, how to license them and oversee their work, a sort of nuts and bolts subcommittee. And then finally, a subcommittee on non-attorney ownership.
So, Kenan, how did you go about your work? What was your method of gathering information and getting the views of others and analyzing the information you were able to gather?
Well, so as has been mentioned a few times already, Texas wasn't the first one to consider this. And so one of the things we did as an initial matter is look at rules from other jurisdictions and also orders from other jurisdictions to see what was happening there, understanding the unique parameters that had been set for our work. Similarly, we looked at the ISLES report that's referenced, I think, in footnote 11 of the working group report, because that had kind of combined, if you will, everything that was being done or being considered across the United States. So that enabled us to sort of drill down more readily than we could have if we had tried to do that work initially. We also engaged the National Center for State Courts. Harriet Myers was instrumental in getting that done for us, and it was invaluable. And I say that not lightly, but meaningfully, because what they did is brought to the table a wealth of information for us and also helped us to compile information, run the meetings, put together the report, et cetera. We invited subject matter experts to speak to the working group that was put together, some of those being people from other jurisdictions where these procedures and whatnot had been implemented. We also, with NCSC's assistance, had focus groups to get feedback from the community from various people with diverse perspectives. In addition, NCSC coordinated with our assistants in terms of who would receive a survey that went out to a lot of people and compiled those results for us to look at. Additionally, and I think critically for anybody who's considering this type of project in their jurisdiction, we engaged the State Bar of Texas early on by sending out a communication that let the members know what was going to be happening, and created, with the State Bar's assistance, a suggestions email address so that anyone could send feedback at any point along the way. And in fact, that email address remains live to this day. In terms of trying to ensure diverse perspectives, the effort was multifaceted, as you might imagine. So first and foremost, we have a commission. That's a great commission. We listened to them, talked to them about who to have on the working group, and we tried as hard as we could to ensure there was diversity of perspective, geography, et cetera, on the working group level. Then, as has been mentioned, we had subcommittees that were formed. Those subcommittees extended beyond the working group membership. So what we did is intentionally tried to get people with relevant expertise and with diverse perspectives to be on the subcommittees. One small example of many, on the subcommittee I was chairing on scope of practice, we were going to be looking at evictions issues. We had a representative from the Texas Apartment Association and also representatives from legal aid. That was important to have robust discussion and ensure all perspectives.
So, Michael, as Justice Busby suggested, there are some embedded interest in the current state of regulations, and as we look around the country, similar proposals generated differing views. What did you hear most often, both about the potential promise of what you were considering as well as the perils?
Yes, well, everybody says they agree there's a justice gap and that it's a problem, but then what to do about it produces some fairly divergent perspectives. Now, candidly, the strong support for the kinds of regulatory reform that we've been talking about and that we studied, I found it comes primarily from those who've already been converted. These tend to be innovators, academics who understand that the status quo is not enough, and that's why we've got to find new ways to expand access to justice. But I didn't find a large group of lawyers for whom it was instinctive to think that we have to correct our existing rules in order to encourage reform. The learning curve is a little steep for those of us who've been taught since law school that strictly enforced boundaries on who is allowed to provide legal services are essential to preserve the integrity of the legal profession. But on the other hand, the opposition to these reforms is organized and highly motivated. We heard some of the themes to the opposition from Justice Busby. We heard repeatedly that allowing non-lawyers to provide legal services will turn law into a business that will not put client interests first, that lawyers working for firms with non-lawyer ownership will sacrifice their independent judgment and advice to clients in favor of maximizing profits. We heard that non-lawyers cannot be trusted to observe fundamental ethical principles, such as preserving client confidentiality and avoiding conflicts of interest. Even limited experimental programs to gather data and see if it's an idea worth pursuing are a foot in the door that will lead down a slippery slope to private equity controlling all law practice. And so the solution to the justice gap is simply fully funding legal aid, and that there's no evidence that reform proposals will actually increase access to justice. Of course, there are very good responses to all of these concerns, but those are the kinds of things that we commonly hear.
So, there's a number of people in this room who are not from Texas, and we're sharing and broadcasting this panel, and we'll preserve it for subsequent listeners, and many of whom will not be from Texas. And all of us are wondering what happened. What are your recommendations? And Kenan, why don't we start with you with regard to scope of practice and paraprofessional licensing?
Absolutely. And I think before I dive in, it's important to say that while there was, of course, some opposition, there was a lot of compromise and listening and productivity. This was an exercise that unexpectedly led to a lot of diverse views being expressed. But what I'm about to tell you, I think yields the progress that came about from the conversation. So first and foremost, we could go on and on and on about the substance of these recommendations, but you don't want us to do that. So there's a barcode in the materials here, and that'll take you to the working group report. The working group report has all of the recommendations that we're going to summarize at a very high level for you now. Specifically for the scope of practice subcommittee that I was fortunate to chair, the rule proposals are laid out in Appendix A to the report on pages 1 through 4. And then if you want to get additional information about the process, the discussion, and the recommendations, you can also look in the report at pages 28 through 35 and 40 through 46. But here's the real high-level overview. You'll see that we have recommended in the materials, this comes from the subcommittee, and with slight tweaks was approved by the working group and then approved unanimously, by the commission. We have a proposed new paraprofessional scope of practice rule, as well as proposed amendments to an existing Texas Rules of Civil Procedure that govern justice court proceedings. So as we've heard several times already, the focus of this work was on helping low-income Texans. One thing we had to do with that focus is define what low-income means in this context, because as a lot of you know in this room, that can mean a lot of different things in the space we operate in. So then what we did is identify the greatest area of need for increased access to justice for low-income Texans. That was family law, consumer debt, probate and estate law, and evictions. So what you'll see in the proposed new scope of practice rule are provisions for what licensed paraprofessionals can do with and without attorney supervision in the areas of family law, consumer debt, and the probate and estate law. You don't see eviction there, and there's a reason. In Texas, we already have a rule that allows authorized agents to assist both parties in eviction proceedings. So that's already on the books. We didn't need to put that in the new rule. However, you've also heard about this community justice worker model that's in Alaska. That's something that is addressed in the proposed amendments to the justice court rules. It's modeled after Alaska, but has a unique spin because we're Texas. And we need that. And so you'll see that that's addressed there. Also in our existing statewide rules for justice court proceedings, there is a provision that allows assistance. It's not defined, but it's allowed in any kind of justice court case. So what has been recommended in the proposed amendments is to relax the standards there a little bit and allow assistance with a little bit more discretion given to the justice of the peace along the way. I think it's also important to point out in the proposed new scope of practice rule that we did address what happens if a case develops in a way that it exceeds the scope of your license. That was something we knew might come up for these licensed paraprofessionals because it is limited scope representation. There's also provision allowing for requiring a written engagement agreement in those spaces. And so I could say a lot more, but I'll stop there for for time purposes and let you all just look to the recommendations. And of course, if anybody wants to discuss them in greater detail, you all have the contact information. I think I'm now covering Lisa's subcommittee, which is the paraprofessional licensing subcommittee. Lisa Hobbs was the third co-chair of the working group and due to various reasons could not be here with us today.
Particularly rain.
Particularly rain, lots of rain. And so I'm going to go over at a high level the recommendations from her subcommittee. So those recommendations are again in Appendix A to the working group report, specifically on pages 5 through 10. 5 through 8, and then on 10 through 20, you see a model character and fitness assessment. For more information about what her subcommittee did, the process, the meetings, the discussion, you can look at 35 through 38 and 47 through 50. I think before I tell you a little bit more about the recommendations from Lisa's subcommittee, it's important to point out that they had as a goal to create regulations commensurate with relatively low potential for harm given the limited scope of practice authorized for these licensed paraprofessionals. We had seen in other jurisdictions that if you overregulate, sometimes that can impede progress. And we didn't want to overregulate, but also didn't want to expose anyone to any unnecessary harm. And so there was a constant effort to balance those interests along the way. If you look at the recommendations in Appendix A for licensing, you'll see a section on qualifications, and that's a combination of education and experience. You'll also see that there's a definition of paralegal in there because in Texas and perhaps in many other states, a paralegal can be many, many different things and come with many, many different degrees of knowledge, experience, etc. There is a section in the proposal as well for examination. The proposal is to have a 1-hour ethics examination, also to have a 1-hour competency examination. There are some circumstances under which somebody can get a waiver. For example, in Texas, we have board certified paralegals in certain areas of the law. They wouldn't need to take a test to show what they've already shown through other testing. There's a character and fitness section in there for assessing character and fitness of the applicants. Again, as I mentioned, there's also a model assessment that's included to simplify matters for people. There is a code of ethics in these proposals. It's modeled after a national code of ethics for paralegals, but then modified, of course, for the licensed paraprofessionals at issue in this proposal. Finally, we have annual licensing requirements set out. There are dues that will be required. It's expressly stated that they would be less than the dues for attorneys. There's continuing legal education requirement in there. There are reporting requirements, and I think this is really important because one of the struggles that we have in the access to justice space is sometimes assessing what exactly is the problem. And so here, if the court were to go forward with the proposal, it would yield reporting requirements that could hopefully give us a little bit more insight in terms of how this program is working in the future.
Michael, what did you see with respect to non-attorney ownership of legal entities?
Yes. So in response to the Supreme Court's request, our proposal was to have a limited modification of the existing rule that prohibits non-lawyers from having any ownership interest in a law firm so that a pilot program could be implemented to experiment with these firms and non-attorney ownership, providing legal services to low-income Texans. And people often ask, what is envisioned by that? Congresswoman Fletcher was talking about how important it was to secure a name change for a victim of domestic violence. There's a non-lawyer-owned firm right now providing very low-cost name changes in jurisdictions where that is authorized. There's another firm that's very effectively and at low or no cost helping people obtain criminal expunctions. And so these are the types of services, legal services, that low-income people need and can be delivered at much lower cost than traditional legal services would provide them. How would our pilot program implement that? We suggested using an existing regulatory body that our state Supreme Court already has legislative authority to assign things for regulation to. There would be an application process and procedure as well as rule guidance to ensure that any of these entities that wish to provide legal services would actually provide legal services that are actually needed by low-income Texans. Some of the important features of that process, which we developed through lots of conversation with lots of the people who are expressing concern about such a change, include requiring that the proposed legal services be described in detail, including how they will expand civil access to justice for low-income Texans. And these firms wouldn't be allowed to provide any other service than these services that are specifically authorized. The firms would be required to make detailed disclosures and perform undertakings to ensure that these services are actually provided to low-income Texans, that they are provided consistent with existing ethical rules, just as apply to attorneys, particularly the protection of attorney-client privilege, client confidentiality, and attorney independence, as well as protection for clients against exploitation or low-quality services that would cause more harm than good. Our proposal would require that there be a Texas licensed attorney employed by the entity who's designated and identifiable to the public as a person who's responsible for ensuring ethical compliance within the firm. Our proposal would require these firms to engage in robust data collection and reporting so that the effectiveness of the programs could be evaluated. And there's much more detail, all in the same report that Kenan referenced earlier. There would be an annual process of reapplication and recertification for these entities in order for them to provide the services. Interestingly, the court did not ask, and our working group did not study or recommend whether these policies should actually be adopted. Our focus was designing a rule modification and change to accomplish it if they were to choose to go in that direction. But due to the overwhelming public comment that we received, which was very heavily in opposition, not to any of the specifics of our proposal really, but to the concept of allowing non-lawyer ownership of firms in general, ultimately our commission voted not to approve the rule modifications that we proposed. But as we've already mentioned, the work has been done and has been provided to the court, so they have our work and our recommendations, despite the vote of the commission not to approve them.
And just to be clear, on the scope of practice and the paraprofessional licensing, what did the commission do?
The commission approved that unanimously.
Right.
Correct.
I should say there were some abstaining votes, to be 100% clear and candid.
And so the next step in the process is what?
So the commission has submitted a letter to the Supreme Court forwarding on the result of the commission's votes, as we just communicated to you, and also sharing the full report of the working group that made its recommendations to the court, as well as links to all of our work that led up to that and all of the public comment, extensive public comment that was received. Ultimately, the Supreme Court will decide what, if anything, it wants to do with that and decide on its next steps. It's our understanding that the court may be considering that soon, but historically, with other types of rule modifications, the court has relied on getting recommendations from a variety of different sources and well-established groups to provide it this kind of advice, including Supreme Court Advisory Committee, that typically will further refine recommendations, including the kind of recommendations that we made in this report. So it's really in the hands of the Supreme Court at this point.
So again, for our listeners across the country who may be in jurisdictions thinking about these sorts of initiatives, what advice would you give them as to how to initiate these sorts of inquiries and think about them and investigate them?
I think one piece of advice would be to decide early on whether the focus of the work will be limited to individuals with low income or more broadly focused to address the justice gap, which of course encompasses many more people beyond those who have low income. And I think that's a decision point that needs to be made at the outset because it of course shapes the recommendations at every step. I think another important thing to do is to invite feedback at every step, be open, be transparent. We made a point with the commission's assistance to put information online so people could see recordings of meetings, agendas, et cetera. And I think that's really important because sometimes the fear we feel is of the unknown. And if people can access the information and figure out what's really being proposed as opposed to maybe what they heard or what they thought might come out of it, I think that can help with having informed discussions along the way. And I'm sure there are additional thoughts.
Yeah, Ken and I could probably talk for hours on this, but we won't, knowing how patient you've all been here. One thing I would say is to be realistic about the timing. Of course, the needs are urgent, and we did a lot in the space of just over a year. But every state is different. The needs in every state will be different. And so anything you can do to identify what's specific to the needs of the low-income community of your state, what the deficiencies are, getting that information as soon as possible is very helpful because it's going to mold the direction of the proposals. I'd also say that spending a lot of time on outreach and coalition building is very important. I mentioned the learning curve on some of these reform proposals. It's my perspective that we encountered a lot of, for me at least, unexpected resistance from the legal aid community. People who had suspicion about the concept of anybody providing these types of services for a profit or a business motivation rather than through the familiar legal aid models or pro bono models. And anything we can do to encourage people to think of these as complementary programs that are expanding the number of people who can be served would be helpful to overcome those kinds of suspicions and be more open-minded about new and innovative ways to serve more of the same kinds of client population with the same kinds of legal services that we're just not able to provide enough of and reach enough people with our current models.
So I'm going to give you both an opportunity to speak without a mandate from the Supreme Court to our legal aid lawyers, our private practitioners, our judges, and other leaders, both here in the room and around the country. What's your call to action to improve access to justice in Texas and America?
I think for the private practitioners, a call to action is to always have at least one pro bono matter on your docket. It's easy to do, it's important to do, and I found that many firms support it. Another thing I think is important in conversations with the legal community and others to make sure that we're having the right question running through our minds, because the problem is such that we can't really ask ourselves whether we should do something, but instead ask ourselves, what should we do? Because things have to be done. And I will say this just for myself, I think this happens for a lot of us. We have fear of change and, fear of how these innovations might impact our business and whatnot. And I think we have to be disciplined and as selfless as possible in trying to process that and put it behind us when we assess what's in the best interest of the people in need in our respective jurisdictions.
Yeah, I agree with all of that. And I want to draw on my experience as a judge. I was glad to hear Justice Busby mention self-represented litigants, which are a really big component of the litigants in our court system. I know that the ideal really is for everybody who needs a lawyer to have a lawyer, but the reality is that that's a long way off for us. And there are right now many people in the court system who represent themselves, often very capably, but we need to do everything we can to facilitate that, both for the litigants and for the courts. And so anything we can do to modify rules to make them easier, to enable people to communicate clearly to courts about the relief they're seeking and why they're seeking it, or why they shouldn't be subject to some kind of other legal proceeding against them. And so, of course, the people in this room know what I'm talking about. Legal libraries, court navigators, basic forms that are easy to use, easy to understand online resources. These, I think, should be a major component of our focus and what we're investing in. And also for the courts themselves, because oftentimes if somebody has the time to spend reading something that's been submitted, they can figure out what it's about and help them. But a lot of the submissions from self-represented litigants really do require a lot of effort, and they're very time-consuming. And so supporting our courts with the resources to do that, I think, would go a long way. And then finally, just making sure that we are changing rules to eliminate kind of technical, non-substantive means of flushing people out of the system, rejecting their filings, or technical reasons for refusing relief, when if you just apply common sense and an open mind and an opportunity for a path to justice, you can figure out what people are trying to do and not be overly legalistic about it.
Please join me in thanking Justice Massengale and Kennan for their thought-provoking presentation.